Bringing to the conversation the ranking member of the House Oversight Committee, Democratic Congressman Jamie Raskin of Maryland. Congressman, thanks for being with us this morning. You have some experience in holding Donald Trump accountable as the lead impeachment manager when he was in the days after January 6th. What is your reaction to this sweeping verdict yesterday of 34 counts and 34 verdicts of guilty?
Well, my initial reaction was thank God for the jury system. When we went over to the Senate, having impeached Donald Trump for inciting an insurrection against the Union, there was a 232 to 197 vote in the House, and we were over in the Senate for a week presenting our case, and I think the evidence was absolutely overwhelming, and the defense, as in the New York case, was pretty non-existent. I mean, they did not have a coherent counter-narrative to tell, and yet we were only able to get 57 out of 100 votes, 57 to 43, which is a pretty commanding majority, but we needed 2/3. And I just feel like the jury system is an essential democratic practice and institution because it's a microcosm of the people, and what you get is common sense. People who are willing to take in all of the facts on all of the sides, people who are willing to participate in this justice system that includes the presumption of innocence, that includes the right of the defendant either to testify or not testify, as Donald Trump chose to do, and we're willing to apply the law to the facts. And so, to me, it was a beautiful thing to watch. Obviously, the process is not completely played out. The convicted defendant, in this case, Donald Trump, has the right to appeal, and we should all respect the appeals process like we're respecting the trial process. But I think it was a great victory for the justice system within liberal democracy.
Yeah, that cross-section of Donald Trump's peers in New York City sat and listened for several weeks to evidence and testimony and decided, yeah, he did it. All of it. Congressman, I know you're not surprised, like we're not surprised by the response from your congressional colleagues on the Republican side, but I'm curious for your reaction and your response to how extreme it's been. You've had prominent United States senators saying we are now a banana republic. Senator Marco Rubio saying this reminds him of the stories his family would tell him about Cuba, where there is no rule of law. The extremism that we're hearing, even from the Speaker of the House this morning on television, saying the Supreme Court needs to step in and reverse this miscarriage of justice. What's your response to all of that?
Well, Donald Trump has been like the psychological and cognitive stress test for the Republican Party. And so many of them have failed. Not all of them, not Liz Cheney, not Mitt Romney. There are a lot of them who have said, no, they don't want to go down the road of becoming members of a cult of authoritarian personality. But at this point, many of them are perfectly willing to surrender critical thinking skills and everything they know about the legal system and everything they know about political science and simply give themselves over to the cult of Trump. I mean, imagine if Trump woke up and decided, all right, the game is over. I'm going to admit all of these crimes, all of these offenses against the Constitution. What would they do at that point? Would they still be yelling, no, no, let's stick with Trump. Let's keep going down the road to authoritarianism. But it shows that they are really acting like members of a religious cult who are sleeping on the basement floor someplace, just listening to the tapes of the cult leader.
So, Congressman, on the issue of the Supreme Court, we know that Chief Justice Roberts has decided to not meet with Democrats about the behavior of Justices Alito and Thomas. But you have a piece that you wrote for the New York Times this week saying there's a way to force those two justices to recuse themselves from January 6 cases. Can you explain that to us?
Well, it's called the writ of mandamus. And that was the writ that was used in Marbury versus Madison. And it's a writ where the Supreme Court, in a case where it has jurisdiction, can tell a federal official, here I argue including a Supreme Court justice, to perform a ministerial act. And the act in this case is the act of judicial recusal, which is compelled, I think, by the Supreme Court's own precedents in the field. And so I canvass some of the different cases where the court decided that there needed to be recusal because there was an objective reality of questions about the impartiality of the judge. And so what the Supreme Court has said in these cases is that what matters is not whether the justice or the judge thinks for himself that he or she can be impartial. The question is, what is the reasonable appearance to the rest of the world? And, I close out by talking about Chief Justice Roberts' analogy he advanced during his confirmation hearings about a judge being like an umpire. Well, imagine an umpire in the World Series of Baseball who was flying the flag or the pennant of one of the teams competing. Would anybody think that that umpire could actually be a neutral, impartial, objective officiant in the game? I don't think so. What if the umpire's wife was trying to overturn the score in the last game, which was the official final score, and was trying to say, let's keep going, let's make this happen? Would anyone think that an umpire in that situation could proceed? And I've been hearing from people in the baseball field, and people who are umpires, saying none of these people would ever be allowed to officiate in a game. And yet these Supreme Court justices have been allowed essentially to be a judge in their own case and to proceed.
All right, ranking member of the House Oversight Committee, Congressman Jamie Raskin, thank you very much. And Doug